Yes, maybe no. Welcome back. Well, this is still TV3 Newday, and it's time now for the big issue. And joining us in the studio this morning is Gabriela Tete. She's a member of the NDC communications team. Good morning.
Good morning.
How are you doing?
I'm fine. How are you?
I'm good. Thank you very much. And also, Elena Madeko is a member of the NPP communications team. She joins us. Good morning.
Hi, good morning.
How are you doing?
I'm good.
Yeah? All right. Okay, and then today, the man of the moment, the reason why we're going to talk about this particular issue, it's come back in the news, especially because he went to court to seek clarification on Articles 102 and Article 104(2) as well, on whether the Deputy Speaker, when he's presiding over proceedings in Parliament, has that right to vote and can form quorum. Well, yesterday, the Supreme Court ruled. It was a unanimous decision, and he's the man that sends that issue to court. And so he's here, lawyer Justice Abdullahi. Good morning.
Good morning.
Everything okay?
Not at all.
Not at all?
Naturally not.
Naturally not?
Yes.
But yesterday you accepted it. You said, well,
Oh,
there's a win. Nobody lost.
Accepted.
There's a win for the Constitution and for Ghanaians. So if you say
so that's
not all is
reference
well,
to that.
Oh, it's not?
Yes.
Something else is wrong with you.
Absolutely.
What's wrong?
He's upset you put in between two women.
Oh, that. Oh, me? What did I do? I had nothing to do with this.
That would be
But
nice.
I mean, of course,
Very nice.
Not too strong
to hear from
women.
the horse's own mouth as
Be
well.
very nice
Two
to you
strong
too.
women.
But that's good. Anyway, so what am I talking about here? So yesterday, the Supreme Court ruled that a Deputy Speaker of Parliament or any other member of the legislature presiding over business of the House does not lose his or her rights to vote while presiding. So such a speaker or member can also be counted as part of the quorum for decision-making in the House under Article 1041 of the 92 Constitution. And there was also another ruling. So yesterday, the court struck down Order 1093 of the Standing Orders of Parliament, describing it as unconstitutional, and they said it needed to be scrapped from the standing orders in Parliament. Let's take a look at what the Attorney General had to say about the ruling. Well, lawyer Justice Abdullahi is here, so we'll get his views on that. But also the minority leader spoke to the press yesterday, and he described it as a deliberate attempt to have government go ahead and pass the E-levy, and so they were not for it at all. Let's take a look at what they all had to say.
Since the ruling expressed utter disappointment.
Everywhere in the world, in civilized democracies, including the United Kingdom, the presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor custom vote. The Supreme Court, to put it aptly, this ruling is judicial support for E-levy, nothing more.
Lawyer Justice Abdullahi, who filed the case against the Attorney General, said he was not surprised by the ruling.
Because I think the Constitution wins, the people of Ghana win, and this is the best decision that I think we should have had. It puts clarity on the law, despite the fact that some of the reliefs that I was seeking were not obtained. But there's a far-reaching decision that has been made by the Supreme Court today.
With more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom. The presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor custom vote. The Supreme Court, to put it aptly, this ruling is judicial support for E-levy, nothing more. Judicial support for E-levy, for a struggling economy in distress, and judicial support for the restoration of a matter that they have said is constitutional, is repugnant to the provisions of Article 102 and 104. With more or less.
They have given their ruling. We have heard. But I believe that there's a reason why our standing orders say that Parliament is the master of his own affairs, and that the procedure in Parliament resides in the bosom of Mr. Speaker. For me, I cannot for the life of me be part of what I would deem an illegality, which would be that the person presiding in the House would take part in a vote he's superintending over. And so I do not know what position my leadership would take or my party would take, but my principled position is one that states that anyone presiding, be it Mr. Speaker or any of his two deputies, has absolutely no business taking part in the vote on the floor of the House. And we will employ every legal means within the parliamentary procedure to ensure that this long time tested practice of Parliament, which is 30 years old this year, will be upheld.
And that's also Honorable Sam George there, also giving his view on this particular ruling. Now, how did this all start? We go all the way back to the 26th of November 2021, when the majority staged a walkout in Parliament at the time when the Ajinkwa budget was to be voted on. And it was because the minority had asked the Minister of Finance, after he came in to address them on the E-levy especially, they asked him to leave the floor, otherwise they were not going to cast their votes. And the majority said, well, if that's the case, then your General Secretary was also up there in the parliamentary chamber, and so they didn't want him there, and so they left the chamber. Now, eventually on the 30th, of course, minority voted in against the 2022 budget, and so it was not passed. Then on the 30th of that same month as well, the Speaker was not around, and so the Deputy Speaker had to preside, Honorable Joe Osei Owusu, and he, for some reason, of course, overturned the ruling to reject that budget, and so eventually it was approved, and minority said that was absolutely wrong. I mean, the arguments was on Article 102, Article 104, in fact, Standing Orders 109 came in as well. So Lawyer Justice Abdullahi decided to go to court to seek clarification on this matter once and for all, and he's here. We want to hear from him exactly why there was a need for that. Lawyer, I'll start off with you.
Thank you. Right, the need in doing that. Principally, I had to do this as a citizen of the Republic. You remember I'm also a lecturer at UPSA teaching law, so every now and then students would always ask you questions on topical issues around the country. So I felt, well, this would be a very good opportunity for all of us to bring a closure to that discussion. If you remember, during the those issues, I was here and I made my views completely known, and this was the same view that I carried to the Supreme Court. Now, my difficulty was waiting for an MPP or an MDC influenced person to take this matter to court. The more you wait, the longer you wait, the most likelihood that one of these persons would sponsor someone or somebody from those camps would end up in court. And it will continuously polarize the discussions. And indeed, even the judgment that will fall from that may not be completely acceptable by the nation. And so I felt, well, for me being the sort of person not associated with any of these political parties, this would be a very good opportunity to get a more acceptable decision from the Supreme Court without any political biases and the discussions that follows from there. So this was the main motivation, to play my civic responsibility to ensure that we have a better systems in place and get clarity and finality, indeed a closure to the issues that had confronted us post-December 2016. Sorry, 2020 election. And I should say that, as I said yesterday, I'm very happy with the outcome.
Are you really?
I am not. No, I'm happy with the outcome. I'm never in doubt at all about my mood regarding that.
Even before you continue, you're saying you're happy about it. There were arguments that Honorable Joe Osei could not form the quorum, especially because he was deciding.
That actually was.
What position had you taken prior to going to court? Were you okay with the fact that he also counted himself as part of the quorum?
Absolutely not.
You were not?
Absolutely.
And so clearly, if you say that you were happy with the Supreme Court's decision, can you expatiate on that?
Thank you. So the position is this, that there is a clarity and finality to this whole matter. This is why I'm happy with it. Not with the entirety of the decision. As for the decision, I have my difficulties with the decision. I've made it clearly known that I cannot understand how the Supreme Court will come to the conclusion that a referee will be a player at the same time. Indeed, if you look at my reliefs, these were not the reliefs that I went to the court for.
What were the reliefs?
The reliefs were to pronounce upon these factors that first, you cannot have a deputy being counted as part of the quorum for decision making. Please, there are two different quorums in reference here. There's a quorum for commencement of business. That is not the one in doubt.
Okay.
The quorum for decision making is the basis for going to court.
And this is based on Article 102?
Absolutely.
Okay.
And then the second part has to do with the voting right. In fact, both the original voting and indeed the casting voting. In fact, the casting voting for me is even more problematic than the original voting.
Why?
Because the casting voting seeks to neutralize the losing effects in the Constitution. The Constitution says that when there is a tie, any motion or any decision that is being taken is considered lost.
Yes.
However, the casting voting gives a deputy speaker the opportunity to completely neutralize this by voting extra. In effect, there wouldn't be a loss. In fact, there would never be a loss as far as that casting voting is concerned, which would operate to mean that every time there's a tie, once the presiding officer would vote for a party or the decision that he is in favor of. And that clearly is an unconstitutional conduct. Because the Constitution says that if there's a tie, that ends the story. The matter is considered lost. But you have smuggled into the standing orders, and it's not plainly stated. It's simply, if you read the Article 1, the standing order 109 3, it simply says that when the person is presiding, he loses only his original vote.
Yeah. But not his casting vote.
It doesn't
because
say
it doesn't say that, yes.
Which means that once there's a tie, the person can unlawfully cast this casting vote.
How do you say unlawfully? Because it also says that the person presiding has a casting vote.
No, it doesn't. It doesn't. This is how the rules are couched. When in reference to the speaker, it says that the speaker loses both casting vote and original vote. It is plainly stated. However, when it comes to the deputies, it's only stated that they lose only the original votes. Silent on the casting vote.
The reason I'm saying that is that when you go to 1092, it says the speaker shall have neither an original or casting vote.
That's the point
and they
I'm making.
argued that in this case, it doesn't say deputy speaker, it says speaker.
Thank you.
And so deputy speaker still holds his position as a member of parliament. So even if it does not state necessarily that he does not have a casting vote, but has an original vote or whatever it is, I mean, as long as he's still a member of parliament, in that case, he can still have a casting vote.
So that's the point I'm making. That I feel that considering the Rule 3, Rule 3 is specific.
It's specific, yes.
On the deputy.
Yeah.
Very, very specific. Rule 2 is general.
Yeah. But that's the thing. You are generalizing, but they're saying that you cannot generalize because it only says.
You see now the need in me going to court.
Yeah.
It's all because of these difficulties in interpretation. So we needed this clarity to be put on. On these issues, and luckily, the decision was made. Now, my point is that I am not comfortable with the decision, particularly when it allows the deputy to be counted, first of all, in the formation of a quorum and also to vote.
Okay.
So these are two different things. First, it allows him to be counted. In other words, instead of having 137 members, assuming we are dealing with the MPP members in Parliament, you rather now have 138 because the deputy who is presiding would be counted as part of it. Now, in addition to that, it's his original vote that he had lost as part of the the standing orders. But now the Supreme Court says that even that part is now completely struck out of the rules. But before then, he had only lost the original vote, but had the casting vote. So prior to the debate on whether to the restoration of the rejected budget. These were some of the permutations that the MPP side were going to court with. That if they go and they lose or it becomes a tie, that casting vote was in the pocket of someone and threatening to utilize that position if it comes to that point.
Well, the Supreme Court has also said that maybe they need to strike out 1093. Of the Constitution.
No, it's been struck out.
The standing orders.
It's not they need to. It's been struck out.
It's been struck out.
Now it's no longer part of the standing
Exactly,
orders.
because it is unconstitutional.
Absolutely.
How do you feel about that?
So that's what I said, that I'm very happy with the outcome generally. And these are portions of the decisions that I'm happy with, because at least we have these all being ironing out, and it's good for all of us. But as I indicated earlier, for a person to be a referee and a player at the same time, that part I cannot accept it.
For you.
Which is why I'm saying that if on Friday, that's tomorrow, we're able to get a decision, I would explore every available means to have the Supreme Court relook at those sections of the decision that I disagree with.
So you apply for a review?
So it is not it's not a firm decision, because it would always be determined on the basis of the reasoning behind the decision that comes out.
Okay, all right. Well, I'll let you go, because I know that you also have to speak on 3FM and have to move to other, media houses as well. But thank you so much, Lawyer Justice Abdullahi,
it's for God and country
speaking
always.
to us. Let me come to Amadeku, because we've heard from the minority in Parliament. In fact, if I can quote what Honorable Haruna Idrisu said yesterday, he says that this ruling is judicial support for E-levy for a struggling economy in distress, and for the restoration of a matter they said was unconstitutional. And so he says that it is a travesty of parliamentary justice and a stop in the growth and development of multi-party democracy built on the spirit and principles of checks and balances. And these are the exact words of Honorable Haruna Idrisu. He is the minority leader in Parliament. In fact, if you listen to Honorable Sam George and also Mutaka Mubarak, they're saying that if this is an attempt to have the E-levy pass, we're still sticking to our guns. We are not going to allow it. Why are you laughing?
They are sticking to their guns, as in. It's a Supreme Court decision that has come, and according to what lawyer just said, that whole section has been struck out. It's out. So what exactly are they fighting?
They say the Supreme Court or the judiciary is interfering with another arm of government, which is the legislature.
How can the Supreme Court be interfering with the legislature? We all know that the Constitution is the highest law of this land, and every single law, it doesn't matter where it is coming from, whether it's from it's from Parliament, whether it's from the executive, whether it's from whoever. If it doesn't go, or it's in how do you call it? It's not in tandem with the Constitution. The Constitution itself tells you it is null and void. Now we have a situation where the Supreme Court of Ghana, by a unanimous decision, this is a 7-0 decision, have said that article or standing order 109, is it section 3 or the whole 109, whichever?
1093.
1093 is unconstitutional. So what exactly is their matter? And what can they do as parliamentarians? What they can do, as Justice said, or lawyer said, is to wait for the whole, the whole dictum to come out tomorrow. And then they can go through. If there's anything that they think it's unlawful, they have to go back for a review. But to say that you will not allow in your position as what?
As the minority in Parliament. And
they will not allow by doing what?
Well, so they're
all of us are under the laws of Ghana. We all serve the Constitution. We all use the Constitution. So if something has come and you do not agree, you go back to the Supreme Court. So that's why I'm asking. That's why I'm laughing. What is it? I really don't see the issue of the minority in this matter. I don't see what their problem is. All of them, from their leadership to the members. It's something that has come up. We are in a novel parliament. This parliament is brand new. We haven't seen anything like this before. So it is expected that people like Justice, lawyer, and others would be testing the Constitution. And that is how democracies grow. If you do not agree with something, you do not resort to unconstitutional means. That is why I keep on asking, how are they going to stop it as it is now? Unless they go for a judicial review. And even with that, if they go, it is two outcomes. It can be They can win, they can lose. So if you go and you lose, you just have to stick with it. So this talk and this bravado and this we won't allow. What won't you allow?
They won't allow the attack on the legislature.
Which attack? And that is why I'm just explaining.
Yeah.
That nobody's attacking anybody. Why would the Supreme Court attack? Well, I mean, I find it interesting. When it is, they are not happy or it doesn't go in their favor, then it is an attack.
Let me
but
explain.
when it goes in somebody, it goes for them, it is the rule of law.
Let me
is that
just
what they are trying
explain
to
what
tell
they
us?
mean by the attack.
Okay.
And I listened to some of them speak yesterday, and they're saying that the judiciary has no power even saying that the Article 1093 is unconstitutional and needs to be struck out.
And why
because
don't the
if you
judiciary
say
have
that, then
power?
that means that you are interfering in the works of Parliament, and Parliament is a master on its own. So it's the same way Parliament can also just get up. So what if now the judiciary says we're striking this out? What if Parliament also decides that they're going to amend the laws concerning judiciary to make things even more difficult for the judges and the entire judicial structure to also work? Would they be happy with that? Because these are two separate arms of government.
This is doubling in conjecture and situations that haven't happened. We are dealing with a situation that has happened now as we talk about it. Now, the Supreme Court, as we all know it, by the Constitution, we have something we call the original jurisdiction of the Supreme Court. And there's one, it's only the High Court. The only thing that the High Court does that the Supreme Court doesn't do is issues relating to human rights. That one you would have to go for your interpretation and everything at the High Court.
Okay.
Apart from that, every single law in this country, it is subject to the interpretation of the Supreme Court, including parliamentary standing orders. If it were not, I don't think justice would have gone, or lawyer would have gone there for interpretation.
Yeah.
Or other people along the line would have gone for certain interpretations on things they do not understand. So, somebody has gone, and he's made it quite obvious that he's not in any way connected to any of the political parties. So he went as a citizen of Ghana. And the Supreme Court by a 7-0, this is not even one dissenting, 7-0, have decided that this is what it should be. And the minority in Parliament are up in arms because of what? That is the question I keep on asking. You are trying to give me their reasons for being up in arms. And I'm saying that their reasons are null and void.
Okay.
If they do not agree, they know the processes they have to go through. But this screaming, we won't agree, we no go agree. Well, unfortunately, the Supreme Court and the laws of Ghana says you have to agree for it as it is now until you go for a review.
So will they be cited in contempt if
I have no idea. I
Okay.
don't think the Supreme Court has... that is my personal opinion, has the time and the energy for this matter. They have other things to do. But, I mean, as parliamentarians, they have a right to also say what they feel. And nobody is stopping them from saying. But we also do have a right to tell them that what they are saying, it won't go anywhere.
All right, Gabriella, so where do you stand on this? Because yesterday the Attorney General spoke and he said that how do you prevent the Deputy Speaker, when he's sitting and presiding over parliamentary proceedings, to not represent his people? Because Honorable Joe Sales, who is the MP for Bekwai, now that time when you're voting for the budget, you're saying that he cannot vote because he's a speaker. But that means that you're cutting out the entire Bekwai constituency from having a voice in Parliament. And that is totally wrong because the law does not bar him from voting or being cast in the quorum as well. And so he is happy with the decision that the Supreme Court has made. What do you say to that?
Well, let me say good morning to our viewers once again and to my co-panelist, Ellen. I'm not a lawyer, so I'm not going to venture into issues of legalities. But I do have some experience in public administration, by training experience. And I'm looking at this from a purely public administrative point of view. Now, when the 1992 Constitution came into being, currently 2022, we've had it for 30 years. The Constitution has not had any proper review of the articles contained in it. However, Parliament has reviewed their standing orders in the year 2000. Now, the standing orders as they stand are provisions and traditions and principles that guide parliamentary processes. So when I hear the decision that 109(3) is unconstitutional. Here's the case that standing orders have evolved. Parliament as a legislative arm of government has evolved over the period. Now, you have a judiciary that is now saying the deputy speaker cannot, that holds,
does not have an original
struck out.
vote. Yeah.
It says a deputy speaker or any other member presiding shall not retain his original vote while presiding. Now, when a person opts to stand as a deputy speaker, or when you are nominated to be a deputy speaker, you know very well the terms of your new role as a deputy speaker, the privileges and the liabilities of that role. So, knowing what the rules are for the speaker, and it is said that the speaker cannot vote, cast a vote, no.
An original vote or casting vote?
Yes, or casting vote. Now, as a first or second deputy, you've now assumed the role of a speaker. So, for me, I'm not a lawyer, as I said, but for me, it's a purely administrative issue. In that role, what is his real defined responsibility? And that is as speaker. In that role, as a member of parliament, even though you represent your constituents, you are still there. But when you take that chair, the responsibilities differ. That is, for me, my understanding of how the administrative setup is organized for parliament. Now, so
does it mean then that at that point when he is the speaker,
when he is sitting,
the Bekwai constituency, you know, Bekwai constituency would not have a rep in parliament?
They have a rep, they just don't have a vote at that moment. But now, I'm in no position to judge what the Supreme Court has decided, because their arguments, even the decisions are not yet out, so you can't even find.
No, it's out. No. We heard even from the Attorney General also saying.
No, I mean the reasoning.
The reasoning is not
out. It's the reasoning that would define how they came to those conclusions, all 7 of them. But I'm taking it from a purely administrative angle, not a legal perspective. When Justice Abdullahi, that's his name, right?
Yes.
Okay. So, in his suit, I think Parliament did not even have the opportunity to give any counter-argument or join the suit or even explain the philosophy and the spirit behind their standing orders. So, this whole thing was just thrown at Parliament that this is the ruling, it is struck out, and you change your standing orders. Fine, the Constitution, as I said, is the mother of all laws, but other laws have evolved to complement that Constitution. Now, in the event where there's this bickering currently going on in Parliament, it's as if both sides are opposed once again on this subject. The minority is of the view that this is political interference.
Yeah.
Because certainly Parliament should have had the opportunity to explain their standing orders. And there's a reason why also the framers of the Constitution aligned, there's this model in public governance, the trial-political model. That is what we call the separation of powers. And it guarantees each of these equal responsibilities and equal powers. So the judiciary per se does not have any overarching responsibility or influence on the legislator. Currently, per their ruling, Parliament can pick the ruling, assess the ruling, compare it to what their standing orders are, and decide whether they'll go for a review of it or they'll amend the standing orders. But I want to leave you with the quote by the member of the Supreme Court of Canada. When, in the case between, there was a majority judgment in Ontario versus Criminal Lawyers Association. And this is what he said about the separation of powers. He said that all 3 branches have distinct institutional capacities and play critical and complementary roles in our constitutional democracy. However, each branch will be unable to fulfill its role if it is unduly interfered with by the others. In Brunswick Broadcasting Company versus Nova Scotia, Speaker of the House of Assembly, 1993, the Supreme Court Report 319 affirmed the importance of respecting the separate roles and institutional capacities of Canada's branches of government for our constitutional order, upholding that it is fundamental to the workings of government as a whole. Underline that. It is fundamental to the workings of government as a whole that all these parts play their proper role. It is equally fundamental that no one of them oversteps its bounds, that each show proper deference for the legitimate sphere of activity of the other. This was quoted by Justice Kaktansis. Now, I'm making this point because, you see, this whole thing came about because of the controversial E-levy.
E-levy, yeah.
And the minority and the NDC believe is that this was just another extension of machinations to try and get an extra vote for the E-levy. But government, unfortunately, I think that they're consistently missing the point on what really true consensus actually means.
Okay.
In this time of our country's evolution and the state that we find ourselves, both sides of the divide have to find a common ground within the national politics of what is Project Ghana. And that is how we are going to move ourselves forward. Now, concerns have been raised about the E-levy. Additional votes coming in to support your numbers. Currently, as it stands, should they decide to lay the E-levy by certificate of emergency within the next 7 days, the LPP will not even be able to come up with their full 137 or 138 membership.
Yeah.
One of their members is not well. Another is out of the country. The others, for whatever reason, have been dilly-dallying, and unfortunately, the LPP in Parliament has been unable to get their members in the House. So it is not a Supreme Court ruling that gives one person an extra opportunity to vote. That is going to change the dynamics. The LPP should learn the state that we find ourselves, and it is up to government to extend overtures to the minority and to get minority on this side. Things are not going to get any easier for us going into the
but
other
how
half
do they
of the
get
year.
the minority on their side when minority has said?
Because,
and in fact,
the
yesterday we heard from the minority leader again, and he says that we remain opposed to the E-levy stage by stage, clause by clause. And so there's really no way they're going to renege on this decision that they've made not to pass the E-levy.
And
how do you think that the majority will get the minority on their side?
Neither will that one extra vote get them to change the situation as it stands. That is why I said extend overtures. Extend overtures. If you and I have to dialogue and we are at opposing ends, there has to be a common ground.
Are you willing to meet them on the common ground?
If they extend overtures. If they extend overtures.
Okay.
Now, currently as it stands, we know very well that there's a gap in revenue versus expenditure, about 27 billion. 6.9 is not going to solve the problem for us. The 6.9 billion is not going to solve the problem.
But the finance minister says it will.
No, it will not.
Because the economy
how
is a
6.9
dire situation at the moment.
How is 6.9 solving a 27 billion problem? A 6.9 per annum. How does it solve a 27 billion problem? The issue is for government to realign expenditure, cut out all those unnecessary expenses. If you have to realign your flagship project, you had a plan to, let's say, do 100 one district, one factories. Currently, you may not be able to do your 100 one district, one factories. Scale it down to 50 or 20 because we've not even seen those factories you are talking about in the first place. Programs like NABCO, for me, left to me, I'll only be interested in keeping the revenue generation model of NABCO. The rest should be paid their monies and allowed to go. Government freezes public sector employment. No more recruitment for the time being. Those four-wheel drives empty with their conditions that are irritating us on the road in a hurry to go nowhere because obviously not solving our problems. Government has to stop those unnecessary irritations, honestly. This, all appointees have saloon cars. There's no reason why you should have four-wheel drives on the roads in the city. Secondly, those who are taking fuel. When I was in office, I had 50 liters a week. The car could only take 30. government has to rationalize and cut the amount you are giving to.
So why didn't you
your
raise
staff
that point when you were in office then? Because if you could only take 30 liters for your car, and they were giving you 50 liters worth,
we are solving the current problem, not
why,
a past problem.
No, but you are saying it now that your car was taking
I cited the example that it was a saloon car, and that was the
why
consumption.
Didn't you raise that objection at that time? Because that was another way of also saving some money in the public purse. Yeah,
so that was why at the time our public officers were told to park their four-wheel drives and use their saloon cars. Because the four-wheel drives are taking about, about almost 100 liters to fill 2 tanks. So park those cars and only use saloon cars. So there are other things that we try to use to deal with our economic situation, as everybody is aware.
But you didn't raise
but at the moment, we are talking about
Gabriela,
a present
I get you,
problem.
But you brought that up, so that's
we
what
are talking
asking
about.
you.
So let's take the current problem. Let's solve money.
Why didn't you raise any
that
objection
is why
about
Ghanaians voted us out. But now we have a present problem on our hand, which is the current.
That detail at that time.
I don't think how much we took for fuel was a decider for how they voted for us. There were other reasons why they decided not to vote for us. Well, you raised it. That's why I'm asking you. But carry on. Anyway, okay. So let me just read something that Josa Owusu said when this whole hula baloo happened, and that's sometime back in November or December. So he said that NDC did not understand, they lacked deeper understanding of Article 104. And 104.2 did say, and does say, that the Speaker, 104 of the 92, Constitution says that the Speaker shall neither have an original or casting vote. And he said that they lacked an understanding, minority lacked an understanding of 104.2. Because if you look at Article 96.1, it is clear that there is a speaker separately and then there are 2 deputy speakers. Because 96.1 is what talks about the 2 deputy speakers who will come in and support the speaker. And so you cannot call a deputy speaker a speaker. At that time when he just assumes the role of the speaker, he's not a speaker. He is only acting in the stead of the speaker. So you cannot use that article then to prevent him from still holding his position as a member of parliament. As a member of parliament and as a deputy speaker of parliament, when he goes and collects his salary, doesn't he see the difference in variation between his colleagues and himself? Because it's coming with responsibilities and liabilities. It's not a question of why we don't understand the law. His interpretation of the law was what caused us the embarrassment in parliament in the first place. That led to Mr. Abdullahi going to seek interpretation of this provision. Now, mind you, even though the Supreme Court has made this pronouncement, Parliament, as I mentioned, has an option to seek a review of that law, which means that technically, that he doesn't have the voting rights currently in Parliament, because it's not in their standing orders currently. For him to go and vote whilst he's sitting there as speaker, the change must happen in the standing orders. So from now till then, he should temper his ego and calm down.
The change must happen in the standing orders.
And let's deal with.
But the 92 Constitution overacts all others. So if you say the change must happen in Parliament, the Supreme Court judges have ruled anyway.
They have ruled, but the order that guides the Parliament is the standing orders.
But they've struck out even 109.
They've struck out 109. I said Parliament has a choice to go for a review.
Okay.
When the real speaker who understands the parliamentary system comes, and I believe that the real speaker is the one amongst all of us who has the best intentions of building a strong legislature in this country, will have a better understanding of the direction that Parliament will go with this.
Ama, so yesterday the Minority Chief Whip also spoke, Honorable Mutaka Mubarak, and he said, and I quote, they say that in Article 102 where it says that quorum excludes the one presiding, that one they agree to it, and was referring to the Supreme Court judges. At the time that they agree that 102 excludes the one presiding, including the first deputy speaker or any member which they agree, that time the first deputy or second deputy speaker is no longer a member of parliament. But where they disagree is 104, where it talks about present and voting. Can you be present and not be counted but vote? We see that as serious inconsistency.
So if he sees it, he should go for review. Honestly, I'm still wondering where the conversation suddenly turned from the Supreme Court's decision on parliamentary procedure to E-levy, then to fuel in cars, and then now we are back to the same old drama, the same old talk about government expenditure. Now, I also find it quite interesting that the minority has to suddenly link this decision to E-levy. Just as Gabriela was explaining, and if we are supposed to go by her explanation, whether the Supreme Court ruled in whichever way, the E-levy will not be passed anyway, because according to her, we don't have the numbers, and according to what the minority leader has said, they still oppose the E-levy line by line, clause by clause, letter by letter.
But if you say according to her, you don't have the numbers. Do you have the numbers in Parliament?
That one, I am, unfortunately, I'm not a parliamentarian, neither am I the whip. So I honestly do not know the situation as at this morning.
Okay.
So it will be difficult for me to say. So whichever way it is, obviously, then this assertion that they are coming up with that it is the judiciary are supporting the E-levy doesn't go. Because whichever decision they give, the E-levy is not going to pass. This is a matter of a citizen of Ghana who thinks that there's an issue, and therefore he went for an explanation. And the explanation has been given by 7-0. And that's, I'm really emphasizing on the 7-0, because if there was no merit in what they were saying, in my opinion, they would not have 7 people, 7 Supreme Court judges, 7 well-versed people in the laws of Ghana, all decided to go one way. Definitely, there should be some merit in what they said. Of course, we still don't have the dictum to it as it, so we are all waiting. But for you to start bringing in issues, this is what the Supreme Court has said. As Parliament, you have to sit down, and as a group, and as a parliamentary group, and as the legislative arm of government, decide on what you're going to do, whether you're going to change your standing orders to suit the new judgment, or you're going to review. That is what you do. You do not stand up and start fighting and casting insinuations at the Supreme Court. This is the decision they have brought. If you had any worry, you should have sent it to the Supreme Court yourself. Somebody else did. And the person has sat here and told all of us that he's happy that the things have been sorted out. He might not agree with certain sections of it, but at least he's happy that it has been sorted out. And then you jump onto this and you start putting in all manner of situations. As for the E-levy, it will be passed or it will not be passed. And the E-levy is not the only bill that is ever going to come up in Parliament. We are going to have other bills going forward. So what are we going to do when other bills also come and this situation comes up? The E-levy is just for today. What about tomorrow? When other things, because this Parliament, we're going to stick with this till 2024.
Yeah.
So other bills are going to come. Other situations are going to rise up. How are we going to deal with it? That is why it is important that people and Ghanaians and citizens do take issues like this to the Supreme Court. But you do not bastardize the Supreme Court because they've given you a certain decision that you do not agree with. Other decisions that you agreed with, you hail them. And it's the same people. It's the same Supreme Court members. So for me, this behavior of the minority jumping at every issue, and the decision just came. You haven't sat down to go through it. You haven't seen the reasoning behind it, and you are already up and down. So when you decide, when you read it, and you agree that, oh, okay, so maybe this is why they said this, are you now coming to come back and tell all of us that you disagreed with what he said at first?
But if they don't agree to it, then I guess that they're
that is
right.
what they all keep on saying, that they are waiting for the reasoning. We all haven't seen the reasoning yet. It will come tomorrow. When the reasoning comes, and then you read it and you realize that, oh, okay, so this is why they said this, and this is why they said this. Are you coming to come back and disagree with what you have agreed to at first? These are the things that I feel we should just, calm down. And she was asking Ujo Osewusu to bring his ego down. I would rather ask her to tell her, the minority, to actually come down on the threats of violence, and won't agree. What won't you agree? It is
How is that a threat of violence?
It is, of course, it is the same we won't agree. That they started off, that they did not agree with the decision of the first deputy speaker to vote in, was it in November or December, that brought us that embarrassment that came to all of us. If they had all sat down and allowed cool heads to prevail, I'm sure we would not have found ourselves in this situation.
Is your side willing to drop its ego?
Which ego?
Well, they have said so many times.
And is their side also prepared to drop their ego?
Government is not ready to drop its
Why
ego.
Are they saying government has an ego? Don't they also have egos? So who has an ego? I don't even understand why the ego thing came into play at all in this matter. It is a decision that you have to take. It is an arrangement you have to reach. You have to agree. That's why you're in Parliament, to either vote for or vote against. So where does the ego matter comes into this?
Not just this, but every other issue as well. I mean,
and it is now. It is in this Parliament. I'm coming.
The NDC quarters.
It is in this Parliament that all of a sudden
government. Maybe it's time for them to come out clean and tell Ghanaians what the real situation on the ground is, even with regards to the economy.
What has that got to do with their getting their processes in Parliament going? There's a Supreme Court verdict that one of your standing orders has been struck out. What are you going to do about it? As a Parliament, you should do something about it.
But who keeps the judiciary in check?
Instead of complaining about somebody's ego. And that's why I also don't get which ego.
Who keeps the judiciary in check? And I'm asking that because when we look at the executive and the legislature, they keep each other in check. But when it comes to the judiciary, they're allowed to just operate on their own, and nobody seems to keep them in check. And I'm saying this because, again, the minority has said that this ruling that you've put out as a Supreme Court, you are also infringing on the powers of
Bella,
Parliament, of the legislature. Who will then draw the attention to it that in this case, you are also infringing on our rights and our powers?
I do not agree on anything that you're saying about the judiciary infringing on the rights of Parliament. They've never done that. The Supreme Court gives them the powers. The Constitution gives them the powers to interpret the laws of Ghana. It is one of their original powers.
But
and so if somebody, all seven of them, that is why there's a review.
The judiciary could get it wrong.
That is why there's a review.
Who then draws the attention to when they actually get some rulings wrong?
That is why.
Unlike the executive and the legislature who keep themselves in check.
There is a review. The Supreme Court has powers to review its own decisions.
But you agree that the judiciary could get it wrong?
I do not agree on this matter.
They cannot get it wrong?
That is why they have dissenting views. Every Supreme Court judge is allowed to make his decision.
But this was
independently. And there are other decisions that they have made that's 4-3.
But this was unanimous. All seven of them.
That should tell you that they all agreed on something. And that doesn't mean that they all agreed on the reasoning. They all agreed on what had been said. But there have been other decisions where you could see 3-2. 4-2. Sometimes it is even 5-1. Sometimes it's even 6-1. That one, there's no problem. But where they all agree on one matter, which we all haven't even seen the reasoning behind the agreement, we are already up in arms accusing them of not acting well. That is what I want us to all understand, that no matter what the situation is, by our Constitution, and until we change it, we have given the powers to the judiciary to determine on every single law in Ghana, including standing orders of Parliament.
To interpret, not to determine, by the way.
To interpret it. And this one, with what they have done, by the powers given them, they can also throw out any standing order or any other rule that does not go in their opinion with the Constitution. And that is why I want all of them to calm down. Most of them are lawyers. And they know. So if there's something that they do not agree, they should just wait for the reasoning tomorrow and then go back for a review.
Does this not make nonsense of the adage that Parliament is a master of its own rules?
You are a master of your own rules in-house. But when your rules go against the Constitution, the Supreme Court has a right to tell you that you have gone against it.
Okay, so you don't think that this also provides fertile ground for a situation where if President Akufo-Addo passes, something or gives approval for something, is out of the country, and someone decides to go to the Supreme Court to try and overturn the decision or seek a declaration, that maybe the vice president who's acting in the stead of the president should overturn whatever ruling or decision the president has made. You don't think that this serves as precedent, the ruling by the Supreme Court?
I don't think so. There are rules, as you just stated. Parliament are masters of their own what? Their own laws. In-house. But when the laws go outside the house and it goes against the Constitution, it is the right of the Supreme Court to determine that and cast it out. The same thing with the executive. The executive does not even have the right to make laws. Or we've forgotten. What they can do is to
But they have executive instruments.
Yes, but then with the executive instrument, it has to come back to Parliament. It has to come back to Parliament. The typical example is the COVID emergency things that the president had. He had to go back to Parliament.
But that's what I'm saying.
So the executive, the two do not correlate.
The vice president could also come to the legislature for an EI to be overturned.
The vice president steps in when the president is not available.
At that point, do we refer to him as the president?
When the president is, right now as we speak, the president is out of Ghana. So the vice president is standing in
as what?
For the president. If the vice president decides to send any bill or decides to make a new rule, it has to go to Parliament. That's what I'm trying to say.
But is it not the same principle?
No, it is not.
Because at that moment he's referred to as what? The president.
The executive.
And so he's not regarded as a vice president anymore, but a president.
Let me finish my point.
So he assumes the role of the president. Is that not the same?
When he assumes
the role, speaker also assumes the role of
when
speaker
he assumes
Parliament.
the role of the president, he does not have the right to make laws on his own. Because the executive, it doesn't matter who is in, whether it's the vice president or it's the president, the executive cannot make laws. The executives have to send their laws to Parliament. So whether it is the vice president or it is the president, you would have to go for parliamentary approval. And so when he gets there and the whole Parliament decides to agree with him, that is another matter we have to talk about. That is very different from somebody else, a Ghanaian, who thinks that there's something wrong with a provision in Parliament, and then he goes to the Supreme Court. That is what our Constitution says you should do. That is very different from comparing what the executive does. The executive arm of government has nothing to do with laws. They cannot pass laws. It is the work of the legislature.
Okay. Gabriela, what do you say to this?
Ellen's job is very difficult this morning. But
what is my job difficult about this morning?
I can understand. I'm surprised that she, of all people, I've been on so many platforms with her, and she's still not become conversant with the fact that no matter how much English I spew, at least I make an effort to think of some recommendations to fix our problems. So it's not a question of me jumping to bring in E-levy and talking about people's egos and fueling cars. We're talking about how to cut expenditure. We're talking about what is the causal effect of all that we are going through. Now, for me, as I said, it's a very simple issue. Parliament will have the opportunity to review the ruling. The Supreme Court has had their say. Parliament has a judicial, Parliamentary Service Board. They have leadership that will review together with the House on what the standing orders say and what this court is also saying, and whether it is struck out or they go for a review of the standing orders and the pronouncements. It's not really a do and die thing. It's a very simple issue. Okay. Honestly.
Let's just quickly move on to this before our time runs out. So the Attorney General also was in Parliament to answer a question concerning
before
the status.
That you mentioned the Attorney General, let me just jump into something.
Okay.
You know, the Attorney General made reference to the fact that in some jurisdictions, the deputy speakers are allowed to vote.
Yes.
And he made mention, was that what you were going at?
No, I was going to move to the issue of Boem, Sal,
okay.
but he said Australia, Canada, USA, Kenya, and South Africa.
Yes, and now, if you look at the US system, their system, what they have and what the British have is different from what we have. We have a hybrid, more like a customized system. The US system has a presidency, Congress, and the Senate, all of which are voted for. What if Parliament decides that if you are bringing this new introduction, that the Supreme Court will dictate the rules governing parliamentary procedure? In that case, Parliament will also decide to bring in a new legislation that says that from henceforth, judges from the Supreme Court all the way to the lower courts, including magistrates, shall be voted for. Can you imagine what will happen in this country?
Somebody else will go to the same Supreme Court and
can you imagine what happened?
And put a bill against it.
And that is how why we have this designed triad political model, separation of powers, and everybody's role is different. In jurisdictions where the legislature is developed and built up, they rather become the most powerful of these arms. So if you take the US system, for example, before America decides to go to war, it is not Biden that will impose the war. It is Congress that will vote and say we are going to war. Biden and his government will only implement. So the executive of that system only implements whatever the Congress says. Congress decides how much we are spending. Congress decides what we are spending on. Your job is to implement it. That is not what we have. Everything in our system is from the executive brought here to Parliament for them to talk plenty, rubber stamp most of the time. I'm sorry, most of the time. And then, for those who know, Akando is here.
Yeah, Honorable Akando is here. And he'll be having an exclusive with Johnny shortly, and so look forward to that.
I'm sure you can speak to that.
Yeah.
Most of the time, rubber stamp because of numbers, and then it is carried on. But the American system is different.
Okay.
The British system is different. So let's rather look at how do we build a stronger legislative arm of government, which will serve we the people. Because at the end of the day, they are the ones who are truly representing our interests.
Your quick thoughts on what the Attorney General had to say about SAL and its representation in Parliament. And he was there to answer questions in Parliament yesterday about the situation. And he says that, well, the best way to go about this is to dissolve the Buem Parliamentary, or annul the Buem Parliamentary election, and allow for a new one so that the people of SAL, which is Santrokofi-Akpafu-Lolobi and Lolobi, can have a representation in Ghana's 8th Parliament.
Oh, I think he gave 2 options.
Okay, but let her just speak to this at least for now.
No, give us the second option.
Hold on, Ellen, hold on.
That we should annul the election of Honorable Kofi Adams and then go for fresh elections. Well, I don't think the NDC is intimidated by fresh elections, what will be the case. But first of all, let's understand the fact that the issue with SAL was actually as a result of the incompetence of some people in government and in the Electoral Commission. Now, here's the case where these people had been petitioning and making their case known on where exactly it is that they believed they were drawn to per what do you call that, regional demarcation, what was that program called?
The ministry that was set up to, yes.
So all these issues came up at that time. And then for whatever strange reason, government just decided to keep suspending, taking a decision on it up until now. And for the past almost 2 years, they've not had any representation. And government now believes that they should, in being asked why they've not laid the paper but on the Guan district, they are rather being told that we should annul the votes of the elections of Honorable Kofi Adams and go for fresh elections. As I said, the NDC is not intimidated by elections. It's our stock in trade to always be going for elections, and we believe in a multi-party democracy. So if that is what the final decision will be, I don't think Honorable Kofi Adams is intimidated either.
He's not intimidated?
He's a very formidable candidate. He can't be intimidated by... In the initial, before the 2020 elections, they had gone campaigning on the grounds that SAL was going to be part of their constituency. But I think about a week or two before the actual election, that was what they agreed on. But for some strange reason, at the actual elections, they decided that they will not allow them.
In fact, it was the night before the eve of the elections when the Electoral Commission released that statement saying that the people of South could only vote took that decision for presidential.
If we have to have another rerun in that constituency, whoever took the decision for SAL not to be allowed to vote should be charged for causing financial loss. Because if they are taking the right decisions, we'll not be having to go back to have another rerun of elections.
Okay, let me hear from Ellen, because the other part of it is that he says that the situation, the only way out of the situation is also the revocation of the LI, which was seeking to create a new constituency.
Yes, and I believe he went to Parliament because he was asked on these issues. And he has preferred 2 solutions to it. So either we wait till 2024, revoke the LI and wait, or we have to rerun the election. At this point where we are 2 years, almost 2 years after I don't think that rerunning the election is going to be of any help.
Okay.
I believe that we should
revoke the LI.
Yes, and then wait for 2024 and then add them to wherever they are supposed to be added. That's my personal opinion.
But that means that for that period, they won't have.
Well, for the
rep
period
in
that we've
Parliament.
been in, they still don't have a rep.
But they've been crying foul about
That is
it.
that's why he has brought the two options.
Okay.
As Gabi said, the NDC is not too bothered about an election. Definitely the MPP will also not be bothered.
Okay.
Ours is that we are ready, let's go, and we go.
All
so
right.
whichever decision they will take, we are all up for it.
Okay. All right. Well, happy birthday to Stephanie and Ponsan Faye of UPSA. You're law students, from your dad and your family. We love you. And also, happy birthday going out. Let me see. Where's this message? Well, anyway, so lawyer Dizita Maklo earlier sent a message saying, tell Abdullah that the issue of casting votes is at the committee level. Okay, and this one is from Stephen. He says that happy birthday to Madam Patience Latte of GNPC. A big thank you going out to Zuri Azilia for styling me. I've been speaking to Gabriela Tete.
Boardroom experience.
Oh, you were watching yesterday. Good morning, Ede Magbana. Well, so Gabriela Tete is a member of the NDC communications team, and Elena Madeko is a member of the MPP communications team. We have an exclusive with Honorable Minta Akando, and Johnny will be conducting that interview. And later as well, we have a big entertainment artist joining us on the show. This is TV3 New Day. We'll be right back with more.